Welcome everyone, and warm welcome to the University of Amsterdam to the event on influence operations in cyberspace and the applicability of international law. And it's a special kind of event. It's a book launch of this book by the author who's sitting next to me. I'm glad to see so many colleagues and interested friends and colleagues in the room, and also we have a number of people following us online. So welcome to those who are following the event on Zoom. A quick word about the organizers of the event. As you've probably seen, this is an event which is organized by ACIL, the Amsterdam Center for International Law, which is the research center at this university for public international law. And within ACIL, there's a specific research program called Law of Armed Conflict and Military Operations, of which I am the director, and we have the co-director, Professor Gill, also in the room, which is dedicated to issues regarding military operations and security issues more generally. That brings me to the topic of today's event, which I think falls squarely into the LL.M remit. And as I mentioned, that the topic of today is influence operations in cyberspace and the applicability of international law. And we will be discussing based on Peter Pijpers' book today, which he originally defended as his PhD in 2022. And which has now recently been published with Edward Elgar Publishers in a commercial edition. So I would quickly like to plug that. This is now, of course, the authoritative volume on influence operations, which certainly needs to be on your bookshelf. I'm not going to try to summarize the book. Peter will introduce the book in a minute. Just to say that it looks, as of course the title already mentions, at influence operations in cyberspace, particularly influence operations dealing with elections, which of course was relevant at the time Peter wrote it, but I think is still very relevant, if not more relevant today, certainly having in mind that this year we will have presidential elections in the United States, we will have elections for European Parliament, and already we see commentators warning for influence operations that might try to manipulate those elections. So I think we're dealing with a very topical subject today, which also interestingly, I think, focuses on what cyber lawyers often call below the threshold. So below the applicability of humanitarian law, below the use of force, which at least in the past has not always gotten the attention that I think it deserves. So in conclusion, I think it's very important to understand what international law has to say on those kinds of operations. And I'm very glad that today we have three experts to talk us through what international law has to say. You'll see that we only have two on the podium at the moment, but the third is on the way. So I'd like to briefly introduce our speakers so that I will not have to do so later. So on my left, we have Colonel Dr. Peter Pijpers, who is a colonel in the Netherlands Armed Forces, also since 2018, an associate professor of cyber operations at the Netherlands Defense Academy, and also a researcher in the LL.M program, which I mentioned before here at the University of Amsterdam. He has a number of publications on cyber operations to his name, including, of course, this monograph. The second speaker or third speaker, depending on when he arrives, is Professor Russell Buchan, who is Professor of International Law at the University of Reading, and who was previously a senior lecturer at the University of Sheffield, and also a British Academy secondee to the UK Foreign, Commonwealth and Development Office. He's a recognized authority, I would say, in the field of international law and cybersecurity, has written a lot, including a number of monographs and edited volumes on the topic, but in view of his secondment to the Foreign Office, is also, I think, someone who has a good knowledge of how the law is applied in practice. And last but not least, I would mention that he was a reviewer for the Tallinn Manual 2.0. I think you will find that that's a common theme throughout the speakers and today's topic. And lastly, but certainly not least, we have Lieutenant Colonel Nick Wobma, who is also an officer in the Dutch Armed Forces and currently posted to the NATO Cooperative Cyber Defense Center of Excellence in Tallinn, Estonia, as a law researcher. He is also the Dutch Senior National Representative for the Baltics there, and he has extensive experience as a practitioner in the field of cyber operations, having served, amongst others, as the legal advisor to the Netherlands Cyber Command. Before we move on to our speakers, just a quick note on today's program. We will have about 15 minutes introduction by each speaker, followed by room for questions and answers. We expect for the program to run for about an hour and a half. We will be recording the presentations, but we will stop the recording after the presentations so that everyone feels free to speak during the question and answer session. And for those following us via the Zoom call, you will be able to ask questions via the chat, which then I will try to follow and also take into account any questions that you may have. So without further ado, I'd like to pass the floor to Peter Pijpers.
Thank you, Martin. Great to be here, great to present the book. Foreign election interference is not a new phenomenon, but the emergence of cyberspace has gained new impetus. And ever since the presidential elections in the United States in 2016, a recurring question, therefore, was, and it dominated the news, have the elections been tampered with? Question have been raised on whether and how these elections were manipulated, and more importantly, in a legal context, do they constitute a potential violation of international law? Activities in and via cyberspace, especially digital influence operations, such as election interference, in contrast to military interventions, as witnessed in Ukraine in 2022, are activities that remain, as Martin said, below the threshold of the use of force. But that does not render them lawful. Influence operations that aim to alter the attitude and the behavior of the targeted audiences, in this case in the ballot box, still violate customary international law. And they could violate international law regarding sovereignty and non-intervention. And based on 3 cases, the 2016 UK referendum, the American presidential elections, and the 2017 French presidential election, in which all cases manipulative influence operations took place, this book assesses if and when the standards of sovereignty and non-interventions are violated. And subsequently, a legal framework is distilled that could guide states executing these kind of operations. Influence operations, what are coined as active measures, political warfare, or covert operations, are nothing new, but have been around for ages. What is new is that cyberspace environment, which has changed the dynamics and the characteristics of the influence operations, not least by adding another vector to the environment. See if this works. Cyberspace is a man-made environment encompassing the virtual dimension, so the logical dimension, the protocols, etc., but also our virtual personalities, and part of the physical dimension, namely the physical network layer. Other appearances like the world around us, so the territory, the buildings, but also our cognition are not part of cyberspace in this particular definition. Activities involving cyberspace are digital espionage, so regular espionage, but now via cyberspace. Operations that undermine or subvert the layers of cyberspace itself. Yeah, it works. And influence operations that make use of cyberspace to change the cognition of the target audiences. The main characteristics of influence operations are the absence of the use of force, the focus on the cognitive dimension, and the objective to change the behavior of the others. Influence operations can therefore best be defined as the deployment of resources by state A for cognitive ends in order to foster or change the attitude of the audiences of state B. So it's an employment of power. Influence operations, it's too fast. Influence operations will utilize persuasive, coercive, manipulative, and manipulative mechanisms to influence this change. Persuasive influence operations aim to change the weighing and the number of options, which are rather benign. Coercive influence operations cut short or circumvent the deliberate understanding and autonomous decision-making of the target audiences. While persuasive and coercive influence operations make use of rational and conscious techniques, so you know you're being influenced, manipulative influence operations make use of subconscious ones. You don't know that you're being influenced. And they subvert or even usurp the autonomous decision-making process of the other actor. Manipulative influence operations make use of the heuristics or the biases, so the mental shortcuts that we have, luring a victim away from the rational decision-making process. The state pursuing strategic narratives and frames. States pursue a strategic narrative and frames to further their objectives. And to engage with others in cyberspace, a range of techniques, including disinformation, trolling, or leaking of sensitive data, are being used. These techniques are conducive to lure that audience away from the rational decision-making process towards a biased one. And to invoke that, they come up with an information deluge. So you have too much information to make a decision, a shortage of time, or lack of meaning and recognition, and the inability to store or process the incoming data. So that's the cyber domain. Let's go to the legal part now. In general, international law applies to cyberspace. Nonetheless, there's room for interpretation. The question how international law applies to cyberspace is still a subject of discourse. When we look at non-intervention, there's one of the elements how you can interfere with another state, infringe with another state, going from the use of force to sovereignty. Non-intervention is the prohibition of intervention is widely considered both a principle and a rule, so an obligation of customary international law, also in cyberspace. An intervention is a non-consensual coercive infringement in the reserve domain of another state. An intervention has two elements: the infringement in the reserve domain, so the domain réservé, the domestic jurisdiction, and it must be coercive. The reserve domain is the area which is, as a general matter, left to the states. So by international law, it's left to the state. Domestic jurisdiction can be limited by international law, both via customary international law, but also by treaties, such as the human rights law treaties. In essence, the reserve domain is therefore a limited question, so it can grow and become smaller. The compelling element of coercion means that there's a deliberate undermining of the ability and the will of the target audience to autonomously make decisions with the aim of the coercer to effectuate a change of policy. You see there the difference, in my view, between sovereignty, the full sovereignty, and the reserved domain. The challenge is that while overtly coercive operations in cyberspace are inherently unlawful, the covert and subconscious manipulative influence operations are not unlawful per se, but they will be if the attributes of the activity, so it's deliberate change needs, it wants a change of policy and undermines the control of the state, if these resemble a coercive operation. So let's go to sovereignty, the next one. Sovereignty is, in my opinion, best described in the 1928 Island of Palmas Arbitral Award, where it says that sovereignty in the relation between states signifies independence. Independence in regard to a portion of the globe is the right to exercise therein, to the exclusion of any other state, the functions of the state. Sovereignty has a firm foundation in international law. Respect for sovereignty is a primary rule of law, a legal obligation, and a breach of which constitutes a violation of international law. Now let's look at this territorial part first. When we look at territorial integrity, we mean the territory of the state, the territorial sea and the airspace above it. Though sovereignty is a legal standard in all domains, including cyberspace, the challenge is how to apply this notion, especially to the virtual part of cyberspace. The most prominent scholarly work trying to qualify this, especially the remote cyber attacks, is the second iteration of the Taliban manual that Marten already mentioned. The Taliban manual lists 3 criteria in which case remotely executed cyber operations could violate territorial integrity: physical damage, functional impairment, and the threshold below the functional impairment, for instance, a temporary loss of functionality. When we look at political independence, that refers to the functions of the state. So those functions that only a state can have, for instance, national defense. The nature of the incursion, also in cyberspace, is the interference with these functions of the state, or more severely, the usurpation of these inherently governmental functions. As said, sovereignty is based on territorial integrity and on political independence. Though international law, including sovereignty, applies to cyberspace, the aterritorial virtual dimension of cyberspace, so our virtual persona, the protocols of software, which is not tangible, does not fit well with this notion of territoriality, with respect of it. While the physical layer of cyberspace, so the computers, the routers, etc., they are part of the territory of a sovereign state. So that is clear. But the question now is how this notion of sovereignty applies to the virtual dimension of cyberspace. And this debate has fueled also the discourse on, is sovereignty a principle of international law, or is it a principle and a rule, an obligation of international law? And the discourse is far from semantic, since an international wrongful act can only be invoked if a primary rule of law, so if an international obligation, is being violated. However, these predicaments do not, in my opinion, render the rule of sovereignty inapplicable. While territorial integrity is difficult to align with the activities in and via the virtual dimension of cyberspace, the infringement of political independence of another state is not necessarily dependent on territoriality. And no damage is needed to constitute a breach of political independence. And therefore, I would argue sovereignty is an obligation in cyberspace. And since remotely executed influence operations via cyberspace do not have a direct territorial dimension, the notion of political independence is the best option to guide states' behavior related to influence operations in cyberspace. That's a big right. So I slowly come to the conclusion. So the main characteristics of influence operations in cyberspace are the absence of the threat of the use of force, the focus on the cognitive dimension, and the objective to change the behavior of another state directly or indirectly via a change of attitude. States enjoy sovereignty over cyber infrastructure, over persons, and cyber activity on their territory, based on territorial integrity and political independence. But the characteristics of cyberspace, especially related to the virtual dimension of it, does not fit well with this notion of territoriality. As a result, some argue that sovereignty, as I mentioned, is not a primary rule of law, which cannot be violated in the sense of Article 2 of the Articles of State Responsibility. Territorial integrity was violated, when I come back to the cases now, during the 2016 US election and the 2000 French presidential elections, but not due to an influence operation. It can be argued that sovereignty, territorial integrity in this case, was breached because Russian agents were on American soil during the American election, and because hackers installed software, malware in this case, and backdoors in the US and in the French election case. Often influence operations are exerted from outside the target state. During these operations, cyberspace is used as a vector to influence the cognitive dimension of the target states. These influence operations have no manifest impact on the territory of the other state and fall below the thresholds that are mentioned in the Tali Manual 2.0, because they have no physical damage, no functional impairment, and oftentimes not even a temporary impairment. It can be concluded that remotely executed influence operations using cyberspace as a vector are not likely to violate the territorial integrity of another state. However, influence operations can violate sovereignty via a breach of political independence. That is a violation of the state functions, not least since damage is not an overarching criterion in this case, as was also in the cases that I studied in the 2016 US election and in the UK referendum. There is, however, a fine line between what is unwelcome and what is unlawful, which makes this case difficult. Foreign election propaganda, diplomatic protest, or purchasing political advertisements, and similarly using social media, a platform to disseminate foreign election propaganda, they are not per se an unlawful interference. They are unwelcome. The state won't like it, but it's not necessarily an interference with the political independence of another state. So that still makes it's difficult. Based on the notion of political independence, that political independence can be violated in cyberspace, it can be concluded that sovereignty is a binding obligation of customary international law in cyberspace, as it is in other physical domains. Influence operations, including manipulative ones, are prone to violate the political independence of another state, and would also violate the prohibition of an intervention, violating the reserved domain in a coercive manner. Manipulative influence operations is not coercive per se, but it can be coercive if it violates the reserved domain in the deliberate manner, with the aim to change the policy of another state and thereby undermining the control of that state. So those are the same attributes that a coercive operation would have, which was the case in my study in the UK and in the US. As a reflection, to summarize, influence operations have not gone away after the presidential election in 2016. There was an influx of operations in 2020 in the US. But there's also quite a lot of influence operations are ongoing at the moment in Ukraine, between Ukraine and Russia, but also in the war at the moment, or the armed conflict in Gaza between Hamas and Israel. Moreover, and I'm sorry to paint a grim picture, but moreover, there's more legal ambiguity in my opinion. While a lot of states were still they hadn't had their legal opinion on what their position would be on international law and cyberspace. We asked them to give their opinion. Now they have given their opinion, but all these opinions are varied. So we still don't have one opinion on how should international law apply to cyberspace. And what is also not helpful is that there are some states, rather a large one, that are still on the fence. For instance, the US and Israel, on how to regard the application of international law in cyberspace. And when states have spoken out on how to apply, for instance, the Netherlands, Germany, France, Canada, they have a different opinion on how it should work. It varies, these are nuances, but still they vary. So on that, thank you.
Thank you very much, Peter, for setting the scene. And I think in your conclusion, you made clear that there's a lot to unpack in terms of international law when we talk about influence operations. You also underlined that a number of states have given in various documents their views on certain aspects of how the law would apply, but no uniform picture emerged. I would say the upside for that is that there's still room for academics to have a role, well, we'll see how that develops. Originally in the program, we had planned now to have a presentation by Professor Buchan. I understand he's on his way, should be almost here, but I'm going to ask for the flexibility of the other speaker, Lieutenant Colonel Wobma. So Nick, if you wouldn't mind, we'll change the order of speakers, and then I will gladly give the floor to you.
Right. So this week I was in a NATO instructor course with all the people of the center where I work, the Cyber Center of Excellence, people from the technological branch, and the idea was to the main event of the week, the grand exam, was to talk for 30 minutes about a topic that you choose yourself. And the guy who was in front of me, a Ukrainian technological guy, he talks about propaganda. So I was like, hey, this is interesting. I just read this book, so let's see what he has to say. And I started to get a little bit anxious because as he was talking about propaganda, I started to notice in my head, yeah, but why don't you define propaganda? I'm hoping to hear something about persuasion or coercion or a covert versus overt or manipulation. And at that moment, I realized, hey, I've learned something. I read this book because you should know I'm normally a legal advisor. So I do look at international law, and I have worked in the field of cyber influence operations. Of course, I did not live under a stone, so I have some idea of the concept and what's going on, of course, and it does pique my interest, but the knowledge that I have about the topic is purely anecdotal or intuitive, or what I read in the newspapers. After reading the first chapters, I also got some concepts that work well, and they work well. They also work well with the international legal part. But before I go there, I get this book, and I also have then the question, who is this book for? Well, I cannot answer that whole question, of course, but I have worked in various legal offices. First, I worked at NATO, NATO CIA agency, and I think this book would go well on the NATO library bookshelf, in the same shelf as the Tallinn manual is, because NATO is often the target of influence operations. Many headlines provided by Sputnik or RT also involve NATO in some kind of way. So it's very important to know what is going on, being able to identify what is going on, and having an idea of the concepts in influence operations. And especially if you're the target of it. On the other hand, there is also a STRATCOM within NATO, so it does connect the dots between the various offices, legal offices towards STRATCOM to have also your own persuasive lines ready that work well in a counter-narrative situations. I've worked, it was like part-time at the Directorate of Legal Affairs and the rest of the time at the Cyber Command Legal office, which was me. So I worked very closely with the Directorate of Legal Affairs. And also there, let's start with the Cyber Command. It would be good to have a book like this. There is a lot of the technical level, the operational level. You need to be able to plan, but you also there you need to know what an opponent is doing, even in peacetime. A cyber command is not a tool for a peacetime operation, not in the Netherlands at least. But you do need to know that if the situation changes and you're deployed to some armed conflict situation, you may need to support your own persuasive influence operations, or you may need to know what the enemy or the opponent is doing in that situation. So also here, from a practitioner's point of view, it's good to have read a book like this. And I see a lot of my military legal colleagues, and I can definitely, if cyber has your interest, this book is really filling that gap. And finally, not finally, because I also work at the CCDCRE now, but at the Directorate of Legal Affairs, of course, this is a book that we know. At the MOD, we are not the first to respond in peacetime situations, so below the threshold operations, but you should always be aware, you should have a close line with the other departments, the Ministry of Foreign Affairs, with the other relevant departments and response departments. So also there, it's relevant. I will get a little bit more into the why. Hey, welcome. So I'll just continue. Welcome. And finally, I now work at the Center of Excellence. We do a lot of exercises there. Big NATO exercises, Local Shields is a cyber exercise, Cyber Coalition is a cyber exercise. And we work closely with the other tracks, is what we call it. So a technical track, an operational track, a media track or STRATCOM track. And in this sense, it's good to connect the dots and that we're not just looking at the legal things and technical people at their technical things, but we get an idea of how it all interoperates. Yes, so in short, for me, the book, in a practical sense, tied a lot of things together, also in the conclusions. So, and for me personally, they also make great legal inject material that we can use in the next exercise run. So that's good. Thank you. About the book, as I was reading it, at first I was going through the chapters and I felt like, hey, I've read this before. There feels like there is some repetition. And that's true, actually, because what I noticed while I was reading is that Peter he adds layers to the same facts. You're seeing the same influence operations or the same elections, but then we add first the layer of the influence operation, then the layer of international law, and that for me made it very easy at some point, at least, to connect the dots. There were some things that while I was reading, I had to go back and read again because they weren't directly clear to me. I mean, I have a background in international law, but sometimes I just need to read very carefully because, for example, I was reading about failed coercive intervention, that it can still be coercive and therefore unlawful, even if it failed it. But if it is interference and it is flawed, it is not per se unlawful. So for me, I had to think really carefully about what I was saying: interference versus intervention, and sovereignty versus coercion. In the end, I read back and saw that in the French case, I finally found that there was a hack, and that in itself was, of course, not good, but it was not coercive enough because it couldn't get to the inherent government functions. It was not a good tool. Whereas in the British example, it was directly meddling with voting, or at least with the perception of people in the voting process. So it became clear to me. And when it did, that was a learning moment. As a practitioner, I always, well, yeah, it always comes back to the UK position on breaches of sovereignty, or sovereignty as a principle versus sovereignty as a rule, not just the UK, the US, and all the various views. I often talk with my former boss and mentor from the Directorate of Legal Affairs International Department, and he told me at some point, and I think that's right, that if you create uncertainty surrounding breaches of sovereignty, the legality of it or the lawfulness of it, then when you're saying that it's just a principle and not a rule, you're not only creating maybe some freedom for yourself, but what also happens is that you cannot tell other people to not do it to you. You cannot have like the legal or moral high ground when you say it's unlawful to breach my sovereignty. And in the Netherlands, you can say that and you can make a clear statement about it, and there is no gap. Whereas in the other countries, you can't really complain if they do that to you, can you? Which in my opinion, that uncertainty can only be exploited more and more as time progresses, because the events in the book are talking about 2016. We've all been in 2020 plus. We've seen COVID and all the things that are going on. Who at some point can still say if it's influence operations or where it's coming from. And that is 2020. Right now, we're at the dawn of AI, and I don't want to start a whole AI debate, but what if you have bots? In the UK situation, if I recall correctly, there were 417 Twitter bots that were impersonating British people and giving false information. Now imagine you have self-learning AI bots that adapt to the situation. What if those bots are programmed to stay under the threshold of this or that? And how do you reply to that in a qualitative sense, because it will overwhelm you, if you don't even have a clarity about the qualitative gap? So in this book, at some point, and I'm not sure if I'm allowed to spoil, but there were some suggestions made in the end that I think fit very well with this whole discussion. It tries to make an end to the whole debate of principles and rules, but it's just a rule. It's more nuanced in the book. So as speaking of AI, when I was a young master's student here at the Institute of Information Law, they already said that the law always tries to keep up with the events, but it's always going to be slower. Can be a good thing, I guess, sometimes, but it can also definitely be a bad thing, because if you can't keep up, you can't deal with it appropriately. So in that scenario where you have all those bots doing automated things, staying right below the thresholds of obviously force, but also coercion, or even of inherent government functions. Yeah, how do we deal with that? So I commend this book for expanding on the existing tools and then arguing in favor of more qualitative tools. But still, as I zoom out and I read the book, I do get an uneasy feeling. So even with these upgraded tools, will it be enough for the future? Will international law remain practical enough to both qualitatively and quantitatively address these concerns? And also, who will advise and respond in a timely version? So I go back now to the practical parts of it. We are all legal offices divided over various organizations. We're not just lawyers, there's also responders, there's technicians, there's decision makers, and we're all in separate offices in separate departments. So who are you gonna call? Not the Ghostbusters, right? And how do you respond in a timely fashion with one voice? So you need to have lawyers that know intimately about cyberspace, sit in the right place at the right time with the appropriate mandate. And you need to declare all the organizational and departmental lines on a national level and an international level. So I digress. I find this book great for helping me, for sharpening the tools for legal action. And as such, I think the book should be on the same shelves as the Talent Manual 2.0. And indeed, it is time to close the door on a breach of sovereignties or sovereignty as a principle only, because it's not helping address bad behavior. I do hope the book and its contents reach its goals and help us with tools to use against the undoubtedly coming onslaught of ever-increasing influence operations. Thank you.
Thank you very much, Nick, for that very helpful perspective from a practitioner, but I think secretly also you made some legal observations that call for further reflection. I'm very glad that Professor Russell Buchan has joined us. He's a bit late, but through no fault of his own, but because of the railways. That's a favorite thing for Dutch people to say. But I'm very glad he's here. And I hope you've been able to catch your breath a bit, Russell, because I previously already introduced you.
Thank you.
So if you don't mind, I'd like to immediately give you the floor.
Thanks, Martin, for your patience and forbearance, and it's great to be here with you today, Peter, to celebrate the publication of your book. And it's good to see old friends and colleagues in the audience as well. I may not be the best international lawyer in the world, but I do pride myself on my professionalism and diligence. So the fact that I'm late is, humiliating for me. But it was a weird confluence of events that resulted in me being late. Many of which were no fault of my own. So I am sorry for that. And anyway, I'm glad I can be here anyway. So let me start by saying a few words about the importance of Peter's book. First, states have sought to influence actors within the international system since the birth of the state-based system. And indeed, since time immemorial, political communities, empires, etc., have engaged in influence operations in order to pursue their interests and secure their objectives. But the advent of cyberspace has changed the threat landscape quite considerably, quite dramatically. Cyberspace enables actors to access huge audiences all of the time. Cyber influence operations can be conducted at speed and at very little cost to the perpetrators. And these operations can be undertaken relatively anonymously, thus posing few risks to the authors, although of course attribution methodologies are improving. So this means that cyber influence operations can be hugely damaging for states and their societies, especially when conducted during times of elections and referendums when sensitivities are running particularly high. Evidently, whether and to what extent international law can be harnessed to dampen and suppress these harmful cyber influence operations is an extremely important, timely and topical issue. And this book will be of keen interest to policymakers and policy appliers who regularly deal with the mar of election interference. Second, I really enjoyed the first substantive chapter of the book, chapter 2, which provides a really interesting, informative, rich, but accessible exposition of the concept of influence, something that's often missing from other international legal assessments of the topic. In particular, this chapter usefully distinguishes between what Peter calls hard and soft cyber operations, so a conceptual distinction that I found to be very, very useful, as I say. This chapter explains what it means to exercise influence in and through cyberspace, and it deals with the profound cognitive impact that cyber influence operations can have on societies, and again, particularly during elections and referendums. So this chapter will be of interest to technologists and strategists looking for a detailed understanding of the anatomy and effects of cyber influence operations. Third, at the heart of Peter's book is his analysis of how the principles of sovereignty and non-intervention apply to cyber influence operations. I'll make some more detailed comments later on about how Peter applies these principles to influence operations. I have a few criticisms, but
Go back a long way.
They go back a long way and run deep, but there's a lot of agreement as well, and I'll pick up on both of those. But just for the moment, the key point that I want to make is that your legal analysis is comprehensive, it's sophisticated, and it's essential reading for those working in international cyber law. But the importance of your legal analysis goes beyond international cyber law. The principles of sovereignty and non-intervention, as we know, are general principles of international law that are critical to the work of all international lawyers. for example, speaking from my own personal experience, I've been recently looking at how these principles apply to suborbital satellites, spy balloons, and unilateral restrictive economic measures. And in doing so, I found myself regularly consulting your book, precisely because it's one of the few works that so thoroughly and clearly analyzes the status, the nature, the content, the scope of the principles of sovereignty and non-intervention. So for all of these reasons, Peter's book is an important and impressive piece of scholarship with wide appeal, being relevant to the work of policymakers, policy appliers, international legal practitioners and scholars, technologists and strategists. Now let me move on to some of the more substantive, the nitty-gritty issues, and in particular, a consideration of Peter's elaboration of how the principles of sovereignty and non-intervention apply to cyber influence operations. Now, Peter, I can't help myself, I think you perhaps alluded to this just a moment ago, but I just want to say a few brief words about the first ground for breaching sovereignty, that is cyber operations that intrude into computer networks and systems without consent. Now, I realise that this is not where the main contribution of your book lies. Your book is about the exercise of influence through cyberspace, but you do discuss this issue, this first ground, the Italian manual first ground for breaching sovereignty. And you deal with this because, as you recognise, some of the case studies that you draw upon and you examine involve non-consensual intrusions into computer networks and systems. So I feel it's fair game. I think the DNC hack is a good example of that, where there was non-consensual access to systems and the exfiltration of data. So if I understand correctly, you take the view that such operations only breach the sovereignty of the target state where they interfere with the functionality of the system or network. This is the majority approach of the Italian Manual 2.0. I can see Professor Gill sat in front of me, and is supported by some state practice. But as you explain, there are other views, and as you explain, France and Switzerland take a different approach. To use Kevin Jonheller's phrase, a pure approach to sovereignty, or the penetration approach, or as I prefer to call it, the wronged personality approach. But it's not just France and Switzerland that have advocated this view. Brazil, China, Guatemala, and others have done so as well. Also, perhaps you're aware that the African Union at the moment is currently working on an African common position on the application of international law to cyberspace. And we know the importance that African states place on the concepts of sovereignty and non-intervention. And I think they are likely to take this pure approach to cyber sovereignty. So as I say, I know that the book is about influence operations, so understandably you don't deal with this issue in a huge amount of detail and only deal with it incidentally. But it seems to loom large over the work. And perhaps in your future research, I'm sure many of us would be interested in, and would certainly benefit from, hearing you develop this aspect of cyber sovereignty in more detail, especially as the debate evolves in light of growing state practice. I still can't get my head around that if a state intervenes, for example, in a state's territorial waters without consent, or into its territorial airspace without consent, I think most of us agree that that would be a breach of sovereignty. I think Italian Manual said that if you send an individual, an agent, physically into another state with a flash drive, they plug it in, download the information, leave, that would be a breach, potentially a breach of sovereignty. So why does that same principle not apply to the cyber domain? So let's move on and look to the second ground for breaching sovereignty, which perhaps is more of the focus of your work, which is interference in inherently governmental functions. I think at page 183, you say that not every interference with the delivery of inherently governmental functions breaches sovereignty. This is of course correct. As you explain, disruption alone would not suffice. Usefully, you contrast the examples of the Brexit referendum and the French presidential election. The former breaching sovereignty, being an interference with inherently governmental functions, the latter not. Again, I agree with this legal assessment. But the question for me is whether you could provide any general guidelines, for example, for policymakers, policy appliers, to help assess when a prohibited interference occurs. So at what point does interference, permissible interference as part of the cat and mouse games of international politics, part of a globalized world order, an interconnected world order, but when's that tipping point? The interference becomes prohibited interference. And you do a very good job of looking at case studies and forensically examining them and saying, okay, this is interference, this may not be, for example, in the context of the French presidential election, but whether you can kind of look forward and provide a general set of guidelines that can help guide policymakers in making these very difficult decisions, because what happened in the Brexit referendum, what happened in the DNC and the US presidential election and the French presidential election, technology changes. So those types of operations, they're going to wax and wane. And I just wonder whether there could be something more. I mean, if you look to, for example, the Italian Manual 2.0, it identifies various factors that can be used to indicate when a cyber operation constitutes an unlawful use of force. I think there's 6 or 8 factors: severity, directness, immediacy, and there are others. That's quite useful, I think, for policymakers. And I wonder whether something could be done around sovereignty. Let's look to now the principle of non-intervention. You correctly say that prohibited intervention occurs where there is coercion in the domain reservé of the target state. So what amounts to coercion is, the tricky question here. And on page 156 of your book, you seem to align with the ICJ's approach in Nicaragua, which is very much about the freedom of choice, protecting the freedom of choice. So coercion occurs in the Nicaraguan sense, where a state compels another state to act or abstain from acting in relation to a matter that's freely entitled to decide. That said, a number of commentators have argued that this is an overly narrow definition of coercion and should be very much read in context, namely that the case concerned military activities, which it did, and was decided during the Cold War in 1986, and was thus very much a product of its environment. So these scholars, but also some states, you'll be aware of the UK's recent position in May 2022, that argue for a freedom of control approach. So not freedom of choice, but freedom of control. And this identifies coercion where a state deprives another state of control over matters falling within its reserved domain. So this definition is much wider. It's a much broader, makes this principle much broader in scope. So my question to you, Peter, is to what extent you are sympathetic to this broader approach? I get the sense that you are. So check page 156, where you actually talk about control. Yeah, in other places, I feel that you're aligning yourself more with the Nicaraguan approach. Of course, this is important because if you look to, say, the Brexit referendum or the US presidential election, which you say were prohibited interventions, I mean, if you're applying that Nicaraguan approach, I mean, to what extent can you say that the UK was forced to do something that it didn't want to do, or the US was forced to do something that it didn't want to do? But you say that these were breaches of the non-intervention principle, they were coercive. So is it really more that what you're looking at is deprivation of control over the state's domestic matters? And then, we can look to other examples that go beyond your case studies. I mean, think about cyber influence operations in the context of COVID. Is a cyber influence operation coercive when it falsely claims that the COVID vaccine did not pass the necessary safety checks and therefore isn't safe? Something that was quite widely circulating on social media in the UK and I'm sure elsewhere, but these were false claims. Does it force the state? Did it force the UK into doing something? Certainly undermines the control, the freedom of control of that state over health policy, which is to encourage people to get the COVID vaccine. So again, my question to you is that, am I correct in saying that I detect a degree of frustration in your writing with that traditional Nicaraguan approach? And you see a broader interpretation of that concept of coercion being both possible, but also normatively desirable. Now let's zoom out, and I think it's fair to say that a fair amount of your legal analysis concerns the spread of verifiably false information, such as in the Brexit referendum. But what about influence operations, cyber influence operations that spread mere opinions or conjecture? So this scenario is closer to the US presidential election because here the influence operations were designed to amplify divisions among the electorate by flooding websites with claims, for example, that certain particular systems and styles of government were beneficial. We can even make our life a little harder. And what about cyber influence operations that disseminate information that correct falsehoods? So imagine a hypothetical scenario where a presidential candidate denies being involved in fraud, but a third state has handed confidential documents clearly showing that they have in fact been involved in fraud. Those documents are released, a wrong is corrected, the public is enlightened. Can it be designated an interference in inherently governmental functions or coercion, perhaps even in the domain reservé? More importantly, should it be? So I think what we need here is a let's go back to my guide, we need to have a principled assessment of how we're going to adjudicate some of these operations. And I think sometimes the perpetrators and the victims involved can skew our understanding. I'm not saying that it does for you, but it does just happen that the perpetrators of these particular operations are Russia, and certainly within other parts of the academic literature. I mean, I'm not saying that affects the analysis in any significant way, but I think we need a much more principled assessment to understand how these principles apply in those types of very difficult circumstances. Let me conclude by saying a few words about the avenues for future research that I think this book opens up, and where I would particularly like to see it and your scholarship go. As we know, this book is about the application of peacetime international law to cyber influence operations. So I have a new idea for a new book, Peter, is what I'm saying. Cyber influence operations under the law of armed conflict. This looks like an open goal for you, given your expertise in influence operations and your expertise in international humanitarian law and your wider experience. Questions include, when do influence operations during armed conflict constitute, for example, the spread of terror among the civilian population, and therefore be prohibited by ACIL? To what extent must parties to armed conflicts take all reasonable care under Article 57.1 of Additional Protocol 1 to avoid civilian harm when undertaking military influence operations, so-called active precaution? Moreover, to what extent should parties to armed conflicts take passive precautions to spare their own civilian population from the harmful influence operations of the enemy? And as current conflicts indicate, this is a hugely important question, and to the best of my knowledge, almost entirely understudied. Finally, in another example, when do influence operations become perfidious under international humanitarian law and even violate international criminal law, engage in individual criminal responsibility? For example, there are reports that Russian forces encouraged Ukrainian forces to go to certain locations in order to surrender, but then launched attacks against them. So I think there's a lot to discuss there, and you're very well placed to answer those questions and to begin that important discussion. So just very finally, by way of conclusion, I think the book has something for everyone. I think it should be widely and closely read. I'm sure it will. Thank you again for inviting me to become a discussant for your book, and I look forward to the discussion that follows.
Sure.
Thank you very much, Russell, for that presentation and your praise of the book, teasing out some substantive issues and giving Peter his work for the next couple of years. What I would like to do before I open up the floor for questions is to give the presenters an opportunity to perhaps react to each other. And I noted that Russell asked the question directly to Peter, so that maybe that's a good way to start. So.
Yeah. Yeah, thanks both for the reflections on the work. Yeah, Russell, you had some almost direct questions and some reflections, which are, I mean, they are spot on, and what you mentioned. Well, let me go first, maybe to indeed how I see coercion, and indeed, it's not only that a state is forced to do so. I agree with that. It should be broader than that. That's why I also almost dissected this notion of coercion. I mean, coercion is not really a legal term, right? It's something that we use in legal context, and therefore I used elements like to have a change of policy, and to aim to undermine the control of the state. I think that's one of the elements, and that is part of the decision whether you can say something is coercive or not. I mean, the freedom you spoke of, so the freedom that a state can do whatever it should, whatever it's allowed to do, that is the part of the reserved domain, in my opinion. But the control part you mentioned, that is part of coercion, and that is not only force. So it's not only that the state is forced to do so, But I did struggle with that in the case of the American elections, for instance. So could I make the argument that Russia, the perpetrator, wanted to have a change of policy in the US? And first I had a kind of a more positive, so what would their goal be? They need to have a clear goal, but then later I changed it to a more negative view, so, but to the opposite one, and I say no, everything that they are interfering what the Americans want to do themselves is already a change of policy. So therefore I broadened it, I tried to broaden it as well. One of the elements that I didn't write that in the book itself, but if it's only force, then coercion will be almost the same as the notion of the use of a threat or the use of force. So there's little difference between the threat of the use of force as a threshold and coercion as a threshold. And if you take that into account that sovereignty might only be a principle, there's quite a lot of room for states to act without them violating any sort of international law. So therefore, my view is that coercion is a rather broad term, and it's not only that a state is forced to do so.
Can I just come back on that? Isn't there, I mean, I understand why the UK is putting forward this freedom of control, not freedom of choice, because it doesn't see sovereignty as a rule. So suddenly intervention, non-intervention has to work much harder. But if you see sovereignty as a rule, and then you broaden out non-intervention, is there not a risk of collapsing the two together? Which then goes on to a second question about the systemic integration of these rules. I know the difference between intervention and force. There's many differences between not least use cogents and all this other stuff. Potentially use of force and armed attack. You know, there's very clear boundaries between them. But yeah, I mean, so when it comes to sovereignty and non-intervention, you know, what's the difference in legal consequences of violating one or another? And I think those questions become particularly acute when the conceptual demarcation becomes very vital.
Yeah, that's the flip side, basically, that if sovereignty is a rule and coercion is very broad, then they are both almost at the same lower level, which should also not be the case. I think that there should be a kind of escalation ladder almost in legal terms. So first you have a breach of sovereignty, then of coercion, of an intervention, and then of the threat or the use of force. But there is an other element to that, and I depict it as 3 circles in my slides. That is not 100% true. From a conceptual point of view, that is how it can be. But especially, I mean, if we look at the state functions as a domain that can be breached is not exactly the same as the reserved domain of the state, because I mean they can overlap. When you look at law enforcement is both a state function, but the state also has the jurisdiction to make rules on and to apply, etc., everything that has to do with it. It's the same for elections. So elections are in both of them, in the center of both. But the way to approach them differs. The one is these functions of the state, which are inherently functions of the state. So not what the state does. In your country, the national health system is something that the state organizes, but it's not necessarily a state function. So state function is really something that the state should and ought to do. And the other is those activities that are left to the state because it's not regulated by international law. So, and again, it can be the same, but their approach is different. So that is also a difference, not only to the thresholds, but also the domain where you look at. But I fully agree with you. If you have the one side, you have coercion and use of force almost at the same, which is the same threshold. If you take my position, in extremo, you have them both, where coercion is so broad that it overlaps with the principle, the rule of sovereignty. Yeah.
Can I just have one quick comment? So you often, with the various case studies, if you find that there's a breach of sovereignty, you usually find there's a breach of intervention, and vice versa. With the French, you say that there's no breach of sovereignty, no breach of non-intervention. So how is it legally consequential to say it's a breach of non-intervention rather than just a breach of sovereignty? Because I see it, the way I understand your work is that you see it as a pyramid, right? So you have sovereignty, then you go up in terms of seriousness to intervention, then you go up to use of force, then you go up to armed attack. And so, okay, so, you know, there's been a breach of non-intervention rather than just a breach of sovereignty. So what, so the intensity of the countermeasures could change? Or is one burger wrong as the other one isn't? Or?
Well, again, the differences are the domain where you look at it, again, as I mentioned. And of course, because in my book, I only look at elections, there you have an overlap between the state function, so the state is allowed to have their elections, and the reserve domain, because the state can also make rules on, etc. But there are probably, I need to think of one, but where the state function and where the state is allowed to make rules. Well, the state is allowed to make rules on private issues. So issues of the private sector, that can also be within the reserve domain of the state, as long as it's not being dealt with internationally. But dealing with issues with the private sector is not a state function. So there you have a difference between the two. And again, the second one is the threshold that you use.